All right, good morning, Civics students. This is our third lecture for the week. You should be watching this for Wednesday. What is it? April 8th. And this is going to be our last lecture. Tomorrow, on Thursday, we're going to have our first live session where we're going to be conducting a review of not only the judiciary, but also Congress and the presidency. So you might want to start looking at those Google Forms assessments in RenWeb to kind of remind you of some of the questions that I posed. But I'm also going to be developing a PowerPoint presentation that I hope you will be able to go through and to help you understand some of the major themes and concepts that we've been studying. You know, we're after our constitutional discussions, we are looking at the three major institutions of government, governmental institutions, Congress, presidency, and the Supreme Court. Then we're going to take a test. So I will post that test. It's open book, open note. Of course, there's really no textbook, but I provided a lot of outside readings and texts on RenWeb to help you. And so open note. And that will be due the following Wednesday when we get back from Easter. So you'll have a week to work on that, and you'll upload that to the document section, or the homework drop portion of RenWeb. So that's the game plan. And after we do the judiciary, we're going to start looking at some non-governmental political institutions. You know, political parties will probably be one. We'll also look at interest groups, campaigns and elections. That'll be a lot of fun. And perhaps if we have some time, we can look at the public policy process. I want to take a look also at some constitutional law, looking at some cases, particularly when it comes to abortion, equal protection cases, Establishment Clause, freedom of religion cases, and a few others. So that's the game plan for after this. But you'll have that test to do, and it'll be due after Easter. Okay, so for this lecture, we're going to be looking at the Supreme Court in three different perspectives. The first is the confirmation process. And so this is how people would get onto the court. Obviously, knowing how the Constitution works, the president has the appointment power, but the Senate exercises advice and consent. And so we're going to be looking at that. And then we're going to be looking at rival theories of constitutional interpretation, which is also highly related to the confirmation process. The two kind of go together because especially in the last 30 years, the Supreme Court has become so much more involved in day-to-day governmental and policymaking that these confirmation hearings, there's so much riding on them because before, particularly in the 19th century, it was always the case that the Supreme Court had a lot of power to construe the Constitution, but they tended to, not go out of their way to aggressively exercise their power. In the 20th century, that became very, very different, particularly after World War II. And as a result, there are, everybody now realizes that if you can get a majority on the Supreme Court, sometimes that's easier to make law than actually trying to influence Congress, try to get a president elected, try to elect governors and state legislatures. So if you can get 5 people to agree with you on a particular policy that is related to a case brought before it, then, maybe that's the easier way to do it. So that's one of the reasons why. So if there is a vacancy on the Supreme Court, it has become extremely, extremely controversial. It's really high-level politics, and if you followed anything recently with the Brett Kavanaugh hearings that happened last year, you know just how especially in the age of social media, how that's just become even more almost like a three-ring circus. So we'll look at that. This idea of judicial activism, judicial restraint, and then the last concept, last theme we'll be looking at is ideas about judicial self-restraint. There's actually quite a lot of history to this, where the court, it's almost like they realize that, like Hamilton said, that at the end of the day, without the ability to enforce their decisions, and without the ability to kind of fund their decisions, they really have to rely upon the well-reasoned judgments of their decisions. And so this idea that it's only in the kind of the most necessary and exceptional cases where the Supreme Court will intervene in a political decision. Now, as I pointed out, I think that has become less the case over the last 30 years. But still, when you take a look at the entire 230 some odd years of the American government, the Supreme Court has done a pretty fair job of kind of husbanding its power and really husbanding and preserving its prestige. When you ask the American public which institutions of government they have the most trust in and which ones they have the least trust in, the Congress always performs the worst. The American public has very few good things to say about Congress as an institution, although they tend to reelect their own congressmen at pretty high levels, so there's kind of a disconnect there. The presidency, especially these days, we're a very evenly divided nation, and the president, depending on the circumstances, his approval ratings will kind of fluctuate up and down. But the court almost always has kept over a 50%, sometimes into the 70s, even to the 80% approval rating of the American public. So there's something about those black robes. There's something about kind of the sober, serious nature of the judicial process that has kept its prestige in order. And I think some of it has to do with the fact that the court has worked hard for that reputation over the course of its own history. So we'll look at judicial self-restraint. Here are the questions that I want you to keep in mind as we move through the lecture. Excuse me. First one, what are at least three major criteria for the presidential appointments of Supreme Court justices? So what are some of the reasons why a particular president will pick a particular nominee for the Supreme Court? And understand this, that there are 8 slots currently for associate justices of the Supreme Court, and then 1 slot for Chief Justice. And that Chief Justice slot is now currently held by John Roberts. Okay, which one do you think is the most significant and why? So of those criteria that you list, which one is the most important? Second question, what does it mean for a president to pack the Supreme Court? Is that a positive thing? Is that a negative thing? And then what has the Senate confirmation become? Why has the confirmation process become so contentious after the Robert Bork hearing? So we'll actually take a look at, this is a picture of Bork with former President Ford and former Senator Bob Dole at his confirmation hearing. Bork was a just brilliant legal mind, but he was a conservative advocate of judicial restraint, and there were people on the left, political left, that were very opposed to his confirmation. And so it's the Bork confirmation hearings that really changed the entire tone of how they work today. And so we'll actually discuss that in some detail. Next question, what is the current ideological and interpretive composition of the Supreme Court? So we'll look at who's on the court now and how do they break down. And then why is the next Supreme Court appointment so critical and going to be politically controversial? Fourth, describe at least 3 rival theories of constitutional interpretation. So we'll look at some of the different ways that almost like schools of thought in terms of how you go about interpreting the Constitution. And then I'll ask you which one do you favor and why. And then finally, over its long history, the Supreme Court has developed several legal principles designed to conserve the authority of the High Court. List and describe what you believe to be the 5 most important of these tenets of judicial self-restraint. So that'll be the last thing we talk about. Okay? So let's talk about the confirmation process. I guess the first thing to make clear is that, when you elect the president, you are electing the Supreme Court. Now, it just has to be kind of the luck of the draw, so to speak, if there is a vacancy on the court. Typically, if you are a 2-term president, you're probably going to get at least one selection. The turnover kind of works that way. I mean, right now I'm looking at I've written it on the board here, but you have, I think the oldest justices right now is, in terms of its tenure on the court, is Justice Thomas, and he was nominated by the first George Bush, and I think 1990, I believe, 1990, 1991. So you think about that, that's, that he's going on, 10, 20, almost 30 years on the court. And then, so, typically a 2-termer, but there are several presidents that have not had any appointments to the Supreme Court. Of the current crop of 9, you have 2 that were appointed by President Bill Clinton, 2 by President Obama, 2 by the George Bush the second, 2 by President Trump, and 1 by the first George Bush. So that is that's the current composition. So this is a way, when you are electing a president, that's certainly one of the important decisions that you have to make is, is the president going to pick people on the court that are in alignment with what, as a voter, you want out of a Supreme Court justice. So it's always been a political process in getting onto the Supreme Court, but because of its, once you get on the court, you stay unless, as long as you have quote-unquote good behavior. So it's a way for a president to have a long, long legacy far beyond when he or she leaves office. And so you can, and if you think about it too, it's a way for a current president, and also the Senate too, because the Senate plays a role obviously in confirming the appointment. It's a way for older presidents and Congresses to kind of check the power of current majorities. I mean, you think about Justice Thomas, he has seen to almost four presidents in his time. And so the country's changed a lot. The issues are different, but he's still on the court. And so George Bush Sr. is still influencing in a lot of ways what goes on that court. All right, and if you think about the current situation, there's a lot riding on the election, the next presidential election. But Ruth Bader Ginsburg is in her late 80s, and she's not. Her health is actually a problem. So there's a great possibility that this might be, the next 4 years might see her resign or maybe pass away. And Stephen Breyer is also someone who's getting up in age. So whoever is president I would predict, would get at least 1 and maybe even 2. And if you think about it, if Trump is able to, if he's able to win re-election, there's a possibility that he could have 3, maybe 4 appointments. That's almost unheard of in terms of recent political history. So anyway, there's a lot riding on, and I think that's why the founding fathers, they wanted the Supreme Court to be removed from immediate politics. That's why they're not elected. But they didn't want them to be completely, especially at the beginning, have no democratic accountability. So these institutions of the Senate and the President allow the public, especially as we've democratized the system, it's allowed the American people kind of a say and who gets on the court. And as we talked about it in previous lectures, and also when we were doing live classes, there's very little political issues that don't, one way or another, end up before the Supreme Court. It's a very, very powerful, important political institution, and really on the face of the earth, I would say the Supreme Court is the most powerful judicial body on planet Earth. Okay, so anyway, so when you think about a president, what are the criteria that he is going to use in order to pick somebody? So the first one, and I think it's something that everyone claims to be concerned about, and I think they are, but you don't get on the short list of being a Supreme Court nominee unless you have good credentials. And what's credentials mean? We're talking about top flight colleges. You know, most of the current Supreme Court have gone to Ivy League schools, whether it's undergrad or graduate school. Now, you might think, well, it's obvious that they would have law degrees, but early in America's history, especially because the law profession really wasn't, a lot of people, like Abraham Lincoln, he didn't go to law school and he was a lawyer. You basically were an apprentice to a other attorney, and you just you passed the bar exam, but you didn't go to school. So today, of course, it seems like almost a requirement that you would go to law school, but not really in the 19th century. And there's nothing that says that a president has to appoint somebody with a law degree. And I actually think it might be somewhat interesting to actually appoint somebody who doesn't have a law degree. You might get a different way of judging that might be actually a little bit more down to earth and practical. But anyway, the point is these credentials are important, and increasingly, even if you have a law degree, the other increasingly more important credential is that you have prior judicial experience. So a lot of these folks, I'm looking at the list here, Gorsuch, Kavanaugh, Alito, Thomas, all former judges on the appellate courts of appeal. I think it's the same way for Ginsburg, Breyer. I think all of them, John Roberts, who's the Chief Justice, they were all former appellate court judges. So that has almost become almost a requirement, although there's nothing in the Constitution that says you have to. What's another? Good school, legal experience, judicial experience. Now, before they become a judge at the lower levels of the federal courts, or sometimes the state courts, the first woman, Sandra Day O'Connor, who was appointed to the Supreme Court by Ronald Reagan, she was a member of the state Supreme Court of Arizona. So sometimes you get those things as well. And I mentioned the first woman, so that's definitely these days an important criteria is race, class, gender. And so look at Obama. Obama appointed two female jurists to the Supreme Court. Clarence Thomas was picked by George Bush Sr. to replace Thurgood Marshall, who was the first African American on the Supreme Court. He was the one that argued the famous Brown versus Board of Education case. And so there's this kind of, it's not set in stone, but there's kind of an idea that there's a African American a seat on the court. There's certainly a woman's seat on the court, and now there's actually 3 females on the Supreme Court. That's, I think, the most ever in American history. Ginsburg is a Jewish American, or at least by heritage and by ethnicity. Louis Brandeis was the first Jewish Supreme Court justice in the early part of the 20th century. So religion sometimes is a criteria as well. It used to be in the 19th century, especially, that region was an important criteria. A man from the South, a man from the West. If you think about it, in some ways, judicial appointments are a way for presidents to appeal to various parts of their political coalition. So if you were a Democrat in the 19th and early 20th century, and you were trying to keep that southern wing of your party, happy, that you might appoint a Southerner. That might be a way of doing it. That's less the case today, but that does happen. And of course, I would say probably beyond race and gender. The second, probably, and maybe even the most important today, is judicial philosophy. And so we'll have more to say about that at the end of the lecture. But, how do you view the Constitution? What are the issues that you think are important? And so and actually the text that I have included in the in RenWeb on the judiciary, they talk about a litmus test. This idea that there's certain issues that the president wants that justice to be for or against, depending upon the circumstances. But at the end of the day, do you look at judging as a way to actually enact social change, kind of a living constitution model, which is one rival theory of interpretation, or do you view judging more as a process of finding or declaring what the law is as written by the people that made the law, whether it's a statute or whether it is a constitutional provision? So that's what we would call originalism. Okay, so this battle between these rival theories of constitutional interpretation or judicial philosophy have become extremely important today, and they mask, I think, more fundamental divisions within our society politically about what they believe to be, the role of government, the idea of rights. Do you have a right to privacy? Do you have a right to an abortion? Do you have is affirmative action something where you actually get preferences because of race and class and gender and all of the rest? So these are highly contentious political issues, and often because the court deals with those issues, the presidents and the people that support them want the president to pick somebody that is in alignment with their judicial philosophy, and their judicial philosophy oftentimes masks a more fundamental ideological convictions. And when we mean by ideology, in this sense, it's kind of an attitude toward what you think the proper role of government should be in society. Do you believe in activist government that is supposed to go out and have a lot of influence and power over people's lives to do good things for them? Or do you believe in more of a limited government, that government usually, in this particular circumstance, is a problem and that it ends up invading people's rights, and so therefore you want to keep kind of government out of particular facets of American life? So those ideological sentiments find their way into these battles over who gets onto the Supreme Court or not. And in a lot of ways, these confirmation hearings have become kind of mini elections. So those are the criteria. Now, next point is, I think there was some kind of notion in the middle part of the 20th century that it was actually illegitimate for a president to pack the court with the people that believe in the way he believes about judicial philosophy, politics, policy, what have you. To me, I think that's kind of out the door. But people still maintain, we need somebody who, the person who should get on the court is somebody who has these great credentials. And that there's somebody who is, good character and all of the rest. And I'm not saying that those things aren't important. But you can find a lot of people with good character and high legal credentials who also are ideologically in sync with what a president and his coalition wants. And so the question, I think that the bottom line is that of course presidents want to pack the court. And I think that they should, because presidents are elected by the American people. And the American people believe, have different attitudes about what the court should and should not do. And if you are able to elect a president and get him into the White House, I think that you have every right and every expectation to think that the president's going to follow through and pick and select justices to the Supreme Court that will do what they think is right. And I think that there is no question, especially because of President Trump's lack of political experience, that when he made that signal that he was going to appoint certain types of justices that would share kind of an originalist frame of reference, and again, we'll talk about originalism in a second, that was a very important political almost ploy. And it allayed a lot of fears of people who were honestly very skeptical. I know, of course, there's still a lot of people who are still skeptical about Trump, but that was a very important calculation that he said, "Hey, I'm going to, I'm going to appoint justices," and he said this all the time, in the mold of Justice Antonin Scalia. Scalia is kind of he is known as the kind of the foremost, before he passed away, advocate of originalism. So Trump put it on the table. He's going to appoint originalist judges, and I think it ended up being kind of one of the most important reasons why someone pressed the lever for Trump, even though they felt like maybe in his character, his personality, that there were some problems with him. But he's going to appoint justices that believe the way I do. So I think that there is. I think it ought to be the case, because if we care about elections and we care about democracy in the sense of a representative system, we want our presidents to reflect what their voters voted them for. Okay, let's talk a little bit about how the process works, the mechanics of it. So let's say you have a vacancy, and we had a vacancy. Anthony Kennedy resigned, and he was a swing vote on the court. More on that in a second. He was somebody who kind of went back and forth between what I would call the judicial activist wing and the judicial restraint wing of the court. But anyway, he decided to retire. He's still alive, but he decided for health reasons and for other reasons that he would leave the court. And so when that happened, Trump had an opportunity to replace him. And when he did, what happens is that the Judiciary Committee of the Senate and the House of Representatives is not involved with this at all. So they would then schedule confirmation hearings, and before that, they would go into his background. They would look at and of course he was a federal judge, so they would look at his past decisions, and they would try to find reasons either to support him or not. Now, I think that because we're so divided politically today, there's a lot of people who believe that these hearings have become, they're not really. The original thought was that they were really designed to be deliberative exercises where people would really be looking at the legal credentials of somebody and then it's kind of high-level discussions of judicial philosophy. But really, what it's become is a high-stakes political election. And if you are against somebody like Kavanaugh, who described himself as an originalist, then they went after him. And if you didn't, I don't know if you followed this, but there were accusations that he had bad behavior at parties when he was in college, and many of which had later turned out to be. Who knew? I wasn't there. I have no idea what happened. But the point was there wasn't a lot of corroborating evidence. A lot of the people who made accusations ended up recanting some of those. But anyway, it was crazy, and a lot of people, were pressing him to resign, or basically to, pull back the nomination. They wanted Trump to pull it back, and this all goes back to this man right here. In 1987, when Reagan appointed him to the Supreme Court, Bork was really a full-throated originalist like Scalia. Now, Scalia was, when he was appointed by Reagan early in his presidency, in his first term, it was 98-2, and Scalia is a very ideological guy. It just shows you how things had changed in 5 years. And so after Bork, they just went after Bork viciously. They went after his background. They looked at the videos that he rented at Family Video, and they searched through. And by the way, interestingly enough, it was Joe Biden, who was the chairman of the Senate Judiciary Committee, that led that hearing against Bork. And so what ends up it becomes kind of a term. To stop someone from getting on the court means to be borked. And so Bork was borked, and he ended up not getting. Now part of this, too, is that the Senate was still controlled by the Democratic Party at that time. and so they had the votes, and so they were not willing to have somebody like Bork, who in his personal life was exceptional, but basically the Democrats just didn't believe in his judicial philosophy, and so they shot it down. And after that, you had another very, very controversial confirmation battle with Clarence Thomas. And this sounds a little bit more like the Kavanaugh experience, where this was the first time where a former female staffer, her name was Anita Hill, accused him of sexual base improprieties in the workplace, sexual, not assault, but basically creating an unhealthy work environment. And again, it was kind of a he said, she said. There were plenty of people who said that Thomas did not do that. And the fact that he was an African American added an entire different kind of twist to it. Now, he ended up getting through the process, and this was with the elder Bush presidency. So those two, the Bork hearings and the Thomas hearings, really, that's kind of a 1-2 punch. And from that point forward, all of these appointments have been extremely, extremely controversial, especially in the age of Trump and social media. And I'm telling you, if he gets another one of these appointments, it's going to be extremely. It's going to be like World War III, is my prediction. Okay. So let's talk about the ideological balance of the court today. Oh, by the way, there's a point called senatorial courtesy. So this doesn't typically happen for Supreme Court appointments, but for lower federal judges, if a president appoints somebody, let's say you're a senator from California, Barbara Feinstein, and it's the Ninth Circuit, and if there's a vacancy on the Ninth Circuit, the home state senators can do something called blue slip a appointment and basically put a hold on it until they get their questions answered. So it's almost like a one senator almost veto. Not to like she's not going to veto the entire appointment, but she's going to have she can use that authority to get some questions answered. And really, if you're thinking about it, you might want to go to her first before you surprise her, to let the president to let her know, or any home state senator in their circuit, to give them the courtesy to know what the appointment is going to be. Another important point that happened, and this occurred during the end of the Bush era and also into the Obama era, is that it used to be that you ended up having to have 60 votes in order to get a judicial appointment because of the filibuster rules and invoking what we call cloture, which is the cutoff debate. Well, they call this thing the nuclear option. The idea is for the Senate to actually change its rules so that the cloture rules and the filibuster threats would no longer be available for Supreme Court and judicial appointments. And that actually has occurred. One of the reasons why somebody like Kavanaugh got through is that there are no filibusters anymore for Supreme Court appointments. So it's a simple majority of the Senate in order to get an appointment through. That's very different than, let's say, Robert Bork or Justice Thomas, where you could have had a few senators hold up an appointment for a long, long time with a threat or even a real filibuster. Okay, so right now it is very, very evenly divided. You have, I would call, a liberal or activist wing of the court: Ginsburg, Breyer, Kagan, Sotomayor, 2 by Clinton, 2 by Obama, and then you have a conservative or a kind of a strict constructionist restraint wing of the court. These are folks that are more originalist in their way of interpreting it, and that is Clarence Thomas, Samuel Alito, Neil Gorsuch, and Brett Kavanaugh. Though they are the conservative wing, the restraint wing of the court. And then the person in the middle, he was appointed by Bush II. His name is John Roberts, and he is the Chief Justice. He is, I would call him, right of center. But he's been very independent. And this is one of the stories about judicial appointments, is that presidents try to pack the court. Sometimes it's easier said than done. And in the one case where a lot of people were very surprised in his decision, it was his decision in the health care, the Obamacare case, where there were people that challenged the constitutionality of the requirement in the bill for people to buy health insurance. Where is it in the Constitution that allows Congress to force someone to purchase a product? I thought it was a slam dunk that that was not constitutional. And actually, Roberts argued that it was not commerce. And so in some ways, he's actually one of these guys that says that there are actually some limits on what Congress can do to regulate commerce among the several states. But what he said was this health care mandate was actually a tax, because if you don't pay for the health insurance, then you are penalized and you have to pay a penalty, which is actually part of a spending. So basically it's Congress's spending power. Now, I think that is a very convoluted way of looking at the bill. I think that opens up an entire can of worms. So you can force someone to buy anything that you want. They don't do it. Then you penalize them. You pay a fine, and that becomes constitutional. I don't get it. But anyway, so Roberts he marches to his own drummer. So it's really 4-4-1. And that's why, if you have anybody in that liberal activist wing retire or pass away in the next 4 years and Trump is president, you are going to get a 5-3-1 split, and that's going to have huge ramifications, particularly on issues like abortion, where I actually think you would have a new 5-vote majority for overturning Roe. Now, that would not mean that abortion would be made illegal. Then it would just be returned to the states where it was before Roe versus Wade in 1973. So that is what has got everybody kind of not only concerned, but kind of on pins and needles because of this, because it's the balance of the court is so narrowly construed. Okay, so let's look at some rival theories of constitutional interpretation. These have already been mentioned, but let's go through them. So the first one, and I think this is really, this was at the beginning of our country's history. I would call somebody like a Jefferson and a Hamilton. They would both not be judicial activists of any sort. I think that they would not be comfortable with the way the court kind of goes around and looks for ways to pass laws through their judicial decisions. I mean, a big part of this today is because Congress has given the court really broad latitude to pick the cases that they hear every year. Remember those 100 to 150 that get to the court in any particular year, where almost all of them, 80% of them, come from their appellate jurisdiction. And it's really up to 4 members of the court to decide whether to hear a case or not. So that you can really, if you're politically savvy on the court, you can pick and choose these cases that you want to come before your court, and then you can rule and try to get a majority of 5 people to go your way, and you can really change the nature of public policy and the law. That certainly happened during the Warren Court era of the 1950s and 60s. It was another instance where Eisenhower, the president, Republican president, Warren was the governor of California. He was a Republican, actually, and he had swung his delegation from Taft to Eisenhower in 1952, and as a result, Eisenhower rewarded him with a seat on the Supreme Court. Well, he did not know that Warren was a kind of a judicial activist by heart, and he ended up, ruling in several cases that are somewhat controversial, especially in criminal procedure cases and Miranda, Escobedo, and the like. The school prayer decisions was certainly one that Eisenhower did not agree with. Anyway, people like Hamilton and Jefferson disagree with each other fundamentally about what the proper role of the court was. Jefferson really didn't think the judicial view was actually a legitimate authority. But whether you would kind of interpret the Constitution broadly, like with the in McCullough versus Maryland with the elastic clause or not. So that was a division between strict construction and loose construction or construing of the Constitution. There's another kind of rivalry between those who would believe that really all judging is declaring what the law is versus finding what the law is. So that's two different ways of looking at it. So finding the law would be something like, okay, was there something kind of not secret, but was there something kind of beyond just the words that were inspiring these people who are members of Congress and presidents to actually pass a particular bill? And that gives more latitude to the judge. So again, you have all these competing theories. One side wants to kind of keep the court away from politics, and another side wants the court to kind of get involved with politics. Okay, there's a literalist way of looking at it. So you read like the First Amendment: Congress shall make no law respecting the establishment of religion, which means if you take a literal approach to that, Congress can't pass any law having to do with religion. Okay, now what does the word respecting mean? What does the word establishment mean? Maybe they can regulate other aspects of religion, but just doesn't have to be establishment of religion. Okay, others will be more process oriented, meaning that maybe the court should involve itself with more kind of separation of powers questions, or questions that deal with where's the balance between the national government and the states, but then staying out of all of these kind of contentious issues, issues having to do with abortion and states' rights. I'm not states' rights, but all these kinds of police questions that really, let's just let the states and localities handle those kinds of things. Then I would say that the biggest division that we have today is this distinction between an original understanding of the Constitution. So the way you interpret the Constitution is you find out what the framers and the founders of the document had in mind. Now, that's easier said than done. I'm not saying that it's impossible, but you have some questions about who are the founders, right? 53 men, do they all agree with each other on all these different parts of the Constitution? How about all the amendments, right? Who crafted the amendments? How about the states that ratified the Constitution and the amendments at different times of our history? Are they founders? Should we look at their particular views on what they were actually approving? That actually seems somewhat logical to me. So it's easy to say, oh, I want the original understanding of the Constitution, but it's a lot harder than what it is, and it takes a lot of work and you almost become, and this is Scalia's point really, that you almost become more of a historian than you are a jurist when it comes to that. The opposite to that original understanding, and then again, that's trying. It's not to say that the court isn't going to make decisions, and sometimes controversial ones, but they're going to try the best they can not to substitute their views on, let's say, the issue of abortion. So, let's take abortion for example. Let's say you're, a devout Catholic, and Scalia was. By you saying that the decision in Roe v. Wade that the court made to strike down Texas's laws prohibiting abortion has nothing to do with whether Scalia thinks abortion is a good thing or a bad thing. All he is saying is that the decision of regulating abortion is not one that should be made by the court. It's not one that should be made by Congress. It's one that should be made by the different states because when you read the Constitution and you read the enumerated powers and you read the 10th Amendment, it's very difficult to find a provision in there that says that a right for a woman to terminate her pregnancy in the first 4 months or before what we call viability, where the fetus can live outside the womb. None of that is in the Constitution. And all Scalia would say is that those the people that should be making decisions about whether abortion is legal or not should be the people at the states level. Or if you had a constitutional amendment allowing Congress to regulate abortion, then that would be the case, but you would still need a constitutional amendment. So it's not so much about what I would argue is the kind of the merits of the case itself, whether you're for or against something like abortion. What Scalia would say, it's more about who should be making the decision. The legislative branch, the executive branch within a state or at the federal level, or judges. And he would say, frankly, that's not the judge's role. Whereas somebody who believes in the living Constitution, this idea that it's the job of the judge to keep the provisions of the Constitution up with the time, that basically you have a whole host of abilities of justices to say, hey, we can protect individual rights and liberties better than Congress or the presidency. And so if we get a case before it, Brown versus Board was a perfect example of this situation. Is having separate schools a violation of equality? Now it mostly was not the case that schools for black kids in the South in the 1950s were equal. But let's say they were. Let's say today, for example, you had a school for all black kids, a school for all Latino kids, a school for all quote-unquote white kids, and a school for all kids from Asia. Let's say they all got the same amount of money. They all got the same facilities and everything. Would that be a violation of the 14th Amendment? It's an open question. Now the court said no, that would be, but somebody who believes in the living Constitution would say you shouldn't even be really kind of worried about these kinds of controversies. It was the right thing to do, and you're a politician essentially. You're kind of almost like a super legislator, and you get to make those decisions. And there's a lot of people who kind of relish that opportunity. And so, when you're appointing a justice and you believe in the living Constitution, in some ways you are appointing somebody who's almost like a Superman legislator. That's the way I would look at it. And if that's the case, you can see why the confirmation process is so controversial, because now you're really electing 9 legislators for life. Now, I don't believe that is what the Founding Fathers wanted. They wanted the lawmaking authority to be in Congress where people get elected. The point of the court was to actually slow down Democratic majorities, not accelerate them. So anyway, those are the different kind of rival theories of interpretation. Last point, and I'll do this in a couple of minutes here, because I know I'm running a little bit late. We have these notions of judicial self-restraint. And so there's several of them, and I'm just going to go through them, and maybe if you have questions about them, you can talk to me or you can send me an email. The first, and this has to do with the court kind of saying that we operate under a different set of standards and a different set of rules than, let's say, the elected branches of government. And part of it is that the court has to have things brought to them. They can't just go out into the world and start rendering decisions on things that they think are right or wrong. Now, I think that because they control their own docket, increasingly it kind of looks like that they are picking and choosing cases that they want to actually involve themselves in political questions. But anyway, it's still the case that for the court to exercise what we call judicial power, there has to be a case brought to it, right? So in order to have a case, you have to have a controversy, and you have to have standing to sue. So one of the big principles of judicial self-restraint is that they have to wait for a case to come before it. And the case has to be adverse, meaning two sides to a question, right? It can't just be kind of set up, we just want to have a case so that the court can rule on it. There actually has to be a controversy. There has to be kind of adverseness between rival parties. They don't give advisory opinions. Congress can't just say, hey, what do you guys think about this Affordable Care Act? They can't do it. They have to wait for a case to come before them. There's these two issues called ripeness or mootness. This ripeness has to do with that there's sometimes when, as a controversy is kind of brewing, that sometimes people will bring a case before there's really actually a controversy, so it's not ripe. And then sometimes a controversy, because of the length of time it takes to have a case heard by the court, sometimes the controversy is over before the court can render a decision. And at that point, all of these are examples where the court would say, hey, look, I'm not hearing your case. You don't have standing. You don't have adverseness. We're not giving advisory opinions. Your case either is not ripe or not ready to be heard, or it's overripe. It's moot. It's done. Okay? When they're dealing with a particular case, particularly on constitutional matters, they're not just talking about, oh, the thing is unconstitutional. How is it unconstitutional? They have to kind of cite specific provisions in the Constitution for the court to actually make a decision. The court isn't going to just kind of allow cases that come to it right off the bat. Most of their cases are appellate jurisdiction, so they want for people to exhaust all lower court remedies before it gets to the Supreme Court. Stare decisis was something we talked about yesterday. Let the decision stand, particularly not so much on constitutional questions, but on statutory matters about what laws mean and what all these huge omnibus pieces of legislation, thousands of pages long. Often, if a court has ruled this way over and over again on a particular provision of a statute, the court's going to say, we're going to follow precedent, and that's what stare decisis means. Political questions, a classic example of this would be, you have a census every 10 years, I mean. We're going to have one soon, if we get rid of the coronavirus, I hope. And then state legislatures are going to draw district lines for Congress and for their own state legislative districts. Should the court be involved with deciding whether those district lines are valid or not? Most courts have said, look, that's a political question. That's for the elected branches of government. We're not getting involved with it. They presume the constitutionality of statutes. It's not the other way around. Oh, the burden of proof is to prove that a law is constitutional. No, the burden of proof is to say that it's not constitutional. Severability, to sever something. Sometimes what they'll do is that they'll say, okay, this part of the bill is constitutional, this part of the bill is not, but you can keep the constitutional part. You just don't throw the entire baby out with the bathwater. I think this is an important one. There's a difference between a law that is bad public policy and a law that is unconstitutional. There's many really bad laws that are perfectly constitutional. And there's a lot of really, really good laws that are not constitutional. Right? So there's a difference between those two things. And then the final point is that if the court can make a decision that says, look, this law, it's not so much unconstitutional, but it's unclear. So they're going to construe the statute instead of doing judicial review. And the reason why they like to do it that way is because if they say that there's a portion of the statute that they think is not valid because it's unclear, you know what Congress can do? They can send it back to Congress, and Congress can actually clarify what they mean through legislative intent. And so that way, the court's not striking down a law, they're just asking the court to clarify. And that's something that increasingly is happening because of the omnibus nature of these huge pieces of legislation. Okay? So that is judicial self-restraint. So with that, I think we're done with the court. Tomorrow we'll do our review session. Please do this. This lecture's questions will be due for Thursday by the end of the day, and then you can start working on your test on Congress, presidency, and the court. All right? We'll see you tomorrow morning. Thank you.